name Madeline Galinea Jose. I am Brinalyn Basi Alforte from OV11. At this moment, I will show to you or I will tell to you my case digest. St. Mary's Academy of Dipolog City versus Teresita Palacio Marijen Calibado, Livy Quilacchio, Elaine Marie Santander, Eliza Sale, and Maria Dolores Monte de Ramos. Government Resolution Number 164913, September 8, 2010. This case was penned by Del Castillo. And now let's move for the facts that we have in this case. St. Mary's Academy of Dipolog City, petitioner assails the decision dated September 24, 2003 and the Resolution 3 dated August 16, 2004 of the Court of Appeals. In the Court of Appeals, Government Resolution SP number 67691, which affirmed with a modification the Resolution 4 of the National Labor Relations Commission or NLRC dated April 30, 2001, holding the dismissal of respondents Teresita Palacio, Marijen Calibod, Livy Quilacchio, Elaine Marie Santander, Eliza Sale, and Maria Dolores Monte de Ramos is illegal. In the late 1990s, petitioner hired respondents Calibod, Quilacchio, Santander, Sale, and Monte de Ramos as classroom teachers and Marlene Palacio as guidance counselor. In 2000, petitioner informed them that their application for school year 2000 to 2001 could not be accepted because they failed to pass the licensure examination for teachers. According to the Department of Education, Culture, and Sports Memorandum Number 10, Series of 19987, incumbent teachers are required to register as professional teachers. Petitioner, on the other hand, dismissed Gail Josephine Padilla, Alma Discipolo, and Marlene Palacio, 11 who were similarly dismissed by petitioner of the same ground, filed a complaint contesting their termination as highly irregular and premature. Ordered petitioner moved to partially reconsider their decision insofar as it found the dismissal of herein respondents to be premature and prayed that respondents be declared legally dismissed from the service. The Court of Appeal, however, denied the motion. Ordered Mariano C. Del Castillo, Associate Justice. Pertinent provision of RA 7836 provide Section 13, Examination, Registration, and License required. Section 26, Registration and Exception. Section 27, Inhibition against the practice of the teaching profession. Section 31, Transitory provision. Pursuant of RA 7836, the PRT formulated certain rules and regulations relative to the registration of teachers and their continued practice of the teaching profession. Pursuant the aforestated law, September 20, 2000, only holders of valid certificates of registration, valid professional licenses, and valid special or temporary permits can engage in teaching in both public and private schools. As respondents are categorized as those not qualified to register without examination, the law requires them to register by taking and passing the licensure examination. And now, let's proceed for the issue. The issue, whether or not the petition is devoid of merit. And then we have the ruling. Yes, in this study stated that on September 22, 2000, the labor arbiter adjudged petitioner guilty of illegal dismissal because it terminated the services of the respondents on March 31, 2000, which was clearly prior to the September 19, 2000 deadline fixed by PRC. Petitioner was ordered to reinstate the respondents or to pay them separation pay at the rate of 1/2 month wage for every year of service, plus limited back wages. Both parties appealed in the NLRC. Dex argued that the grounds relied upon by petitioner to dismiss respondents are not among enumerated by the Labor Code. Respondents prayed for the refund of their retirement contribution and payment of attorney's fees. But then, the NLRC, in its Resolution 16 dated April 13, 2001, denied both appeals. The Court of Arbitration for the Philippines, Court of Appeals, has ruled that respondents' dismissal of Padilla, Marlene Palacio, and Delahao and Discipolo was in violation of existing law. The Court of Appeal also found respondents' acts of retaining and hiring other equally unqualified teachers who do not possess the required eligibility and allowing them to teach for the school year 2000 to 2001 as badges of bad faith. Petitioner insists that it has the right to terminate respondents' services as early as March 2000 without waiting for the September 19, 2000 deadline. And also, petitioner justifies respondent termination by advancing that it would be difficult to hire licensed teachers in the middle of the school year. The dismissal of Teresita Palacio, Calibod Laquio, Santander, and Monte de Ramos was premature and defeated the right to security of tenure. Sales dismissal has legal basis for lack of the required qualification needed for continued practice of teaching limited back wages computed from March 31, 2000 to September 30, 2000, awarded in favor of Palacio, Calibod, Laquio, Santander, and Monte de Ramos are sustained. The petition is partially granted. The decision of the Court of Appeals dated September 24, 2003 in the Court of Appeals Government Resolution SP number 67691 finding respondents Teresita Palacio, Marijin Calibod, Livy Laquio, Elaine Marie, Santander, and Maria Dolores Monte de Ramos to have been illegally dismissed and awarding them separation pay and limited back wages is affirmed. As regards respondents, Eliza Sale defined her termination valid and legal. Consequently, the awards of separation pay and limited back wages in her favor are deleted. The assailed resolutions of the NLRC 5th Division dated April 30, 2001 is hereby affirmed with modification. The monetary awards adjudged in favor of private respondents Gail Josephine Padilla, Virgilio Andelahao, Alma Discipulo, and Merlin Palacio, whose services were legally terminated, are hereby deleted for lack of basis. And that would be all my case digest, and I hope that my case digest was clearly delivered, and thank you, Mama Madeline, for this opportunity.